90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Attorney Ken Landau, and welcome to Law You Should Know. Today we're going to be discussing eminent domain, and with us today is an expert in that field, Attorney Jennifer Polovetsky, and she's of counsel with the law firm of Herrick Feinstein with main offices in Manhattan, and she's the co-chair of their eminent domain practice. Jennifer, welcome to Law You Should Know.
Thank you.
You have a very unique specialty, eminent domain, and perhaps you can start by telling our listeners what exactly that means.
Eminent domain is the taking of private property by the government for public use. So what is a public use? Public use can be anything basically that benefits the public. So it can be a school, a road, a bridge. Interestingly enough, public use is also considered the alleviation of urban blight. So there's a lot of blighted areas, especially in and around New York City and the suburbs, and it is not uncommon for the government in both the city and the state to acquire properties in what they deem to be blighted areas, to redevelop them for housing, retail, and commercial use. And
sometimes the idea of providing land to someone who's going to invest to build a factory, a warehouse, falls under as well. And the government might take that property to create jobs or create a manufacturing hub or something along those lines?
Not usually. The government did take many, many years ago. The city of New York actually acquired property in the Times Square area and built a new building which now houses the New York Times. So that was, kind of on the cusp of a public use because the New York Times is a newspaper publication, so it's media, it's public, et cetera, et cetera. Factory, I don't know. That one is kind of iffy because it might be considered more of a private use. A hospital, a school, a road, a bridge,
a water project, some kind of sewer project.
Water, sewer projects, absolutely.
And perhaps a park. To expand parkland.
Exactly. Parkland, exactly.
And on Long Island, some of the projects you have been involved with are, the adding the third track to the Long Island Railroad, creating the Ronkonkoma hub, and the expansion of Penn Station, which will be going forward. So, and you don't represent the government, you represent the landowner.
Correct.
Whose land wants to be taken by the government in furtherance of these projects.
That is correct.
So just tell us your role in protecting the interests of the landowner. And landowner could be a homeowner, it could be a big billion-dollar corporation.
That's correct. So basically, when the government wants to acquire your property by eminent domain, whether you own a tiny little house that's going to be demolished for a school, or whether you own a giant factory or a building
or a piece of land,
any of it, you will get a notice. You will get a notice from the city, you'll get a notice from the state, you'll get a notice that there's a public hearing. They will contact you, so it doesn't come out of the blue. That's usually when you should contact an eminent domain lawyer. General real estate lawyers are great. I practice general real estate as well. But you really need somebody who knows New York's eminent domain laws because they're very tricky, they're very archaic, and you could leave a lot of money and a lot of rights on the table if you're not represented by counsel who really know what they're doing.
And we'll talk in a few minutes about what some of the issues might be, the legal issues involved. Can you challenge the purpose or the need for the eminent domain condemnation of the property?
You can certainly challenge the purpose or the need for it. However, in New York, your chances of success are less than 1%. This kind of challenge is called an EDPL, Eminent Domain Procedure Law 207 challenge. And after all of the public hearings have concluded and determination findings have been published and you've been, served with this notice, you have 30 days when you're served with this notice to file this kind of a lawsuit. They're very expensive, and you would basically have to prove that the public use is an invalid one. And New York has some of the broadest eminent domain laws in the country. Almost everything is considered a public use in New York. So it's, of course, you can challenge it. And I always tell my clients who want to challenge it, it's highly unlikely that you will succeed. It's generally a waste of money.
But the other more important issue is the compensation for the taking of your property.
That's right. Because
there is going to be a taking, and the government has the right to do it through eminent domain, but you're entitled to compensation. And what is the compensation standard? How can people disagree over what the compensation should be?
So the Constitution, the Fifth Amendment to the Constitution says no taking of private property without just compensation. So the justness of the compensation is what is always fought over. So the government will approach you and they will make you an offer to buy your property before any condemnation occurs. And you can either say, yes, I'll take it. I'll accept your offer. I'll accept it as a settlement in full, or I'll sell it to you, et cetera, and I'm not going to fight you in court, and you can walk away. Or you can say, you know what, I'm not going to take it, and I'll take it as an advance payment. That's a term of art in eminent domain. It's basically, I'll take it as an initial payment, and I reserve my right to file a claim in court for additional compensation. And that's when you get an eminent domain attorney involved. And we get our own appraisers involved. Sometimes we get zoning experts, engineers, architects, depending on the complexity of the case and of the property. Because property in eminent domain is valued on its highest and best use, which is not always the existing use.
So if it was a golf course or a parking lot, that may not be the most value use of the property.
That's right.
But you can show it would have had would have been more valuable someday or with some other use?
Right. So the standard for highest and best use is at the time of the taking. Everything freezes on the date of the taking. It's what is physically feasible, economically viable, and legally permissible. So sometimes you have, and this happened in one of our Long Island Railroad cases, for the third track expansion, we had an industrial property. Half of it was zoned industrial and half of it was zoned residential. But the town of Westbury had actually rezoned the entire area to residential. So our appraiser and our zoning experts determined that the highest and best use for that property was multifamily residential development. So even though that was a piece of land that was being used for a construction business, we ended up settling the case on the eve of trial, basically, but we were able to claim that the highest and best use would have been multifamily residential development, and it was valued as a development site. It's not valued as built.
So if someone makes you an offer, it's good to remember that, a great offer, although you don't want to sell, it's good to remember that offer because it might be important down the road.
Yeah, and you don't, just like in a private sale, you don't have to accept the offer. I mean, the government will acquire your property by eminent domain if they need it, and they have to pay you at least what they offered. They can't take that offer back because that's based on their appraisal, but you can certainly fight for more money.
And you can challenge and review what factors their appraiser considered, because as you said, they may be using the wrong criteria.
That's correct. So they don't give us their appraisal before the taking, but after they acquire it by eminent domain, if it's a Supreme Court taking, 9 months, the statute says that 9 months after the claim is filed, the parties have to exchange appraisals. Sometimes it takes a little longer on both sides, and we extend the time. But basically, the owner's side and the government side, they exchange appraisals. So we get to see their appraisal and they get to see ours. We always caution people not to give any value, any past appraisals that they've gotten, anything to the government, because it may hurt them. It's almost like a criminal proceeding. Anything that you say or do can be used against you value-wise.
And they won't tell you you're right, so they have to rely on you for that.
Right.
Can the government take the property and begin the condemnation proceeding or the rebuilding and let the valuation and compensation continue on the side? Or is the whole project held up while this takes place?
No. They can take the property, they seize the property. And, advance payment is a little bit of a misnomer because usually that payment is not made in advance. It is offered in advance, but the payment is not made in advance. So let's say today was the taking date. Let's say they already went through all the court proceedings, the court approved it. Today is the taking date. And you were offered, I'm just making it up, $1 million. Well, if it was the city of New York taking, they have to pay you 6% interest a year on that initial $1 million up to and until the date that they cut you the check. If it's a state of New York taking, they have to pay you 9% interest per year up on the initial payment up to and through the date that they cut you the check. The same goes for any additional money that you may win in court. So let's say at the end of the proceeding, you filed your claim in court, today, and it took 3 years for it to settle or go to trial and get a final judgment. You're getting, let's go with the 9% interest, you're getting 9% interest for those 3 years on the additional $1 million. So it's to compensate people for the delay in payment.
Okay, and I just want to remind our listeners, we're talking about eminent domain, where the government is taking your property, be it residential, commercial, some small slice of property, or a big field or building for some kind of public use. Our guest is Jennifer Polovetsky, and she is the co-chair of the Eminent Domain practice of Herrick Feinstein. And you've been telling us about some of the projects that have taken place in New York City and on Long Island, and you're talking about New York law, and other states may have some similar laws. Tell us about some of the details. What happened in terms of the Long Island Railroad expansion, the course that the eminent domain proceedings took, and also with other projects you've been involved with out here in New York City.
Sure. The Long Island Railroad third track project is actually complete. It was just recently completed. We had a bunch of those cases. They were all in Westbury. And in addition to expanding the Long Island Railroad by adding a third rail, the biggest part of, or a big part of those projects was eliminating the grade crossings. As you may know, a lot of people were injured and or killed, in their cars while crossing over railroad tracks in past years. So the Long Island Railroad decided, we're going to eliminate that, and we're going to drop the road, basically 30 feet. And so now if you go, say, on School Street in Westbury or, other streets, instead of going over the tracks, there's a dip and you go right under the tracks. And, you don't even feel it, and the tracks kind of go right over you. The train tracks go right over you, but it's really safe and it's really nice. The people that had their properties acquired were in the way. I mean, basically that's what happens with eminent domain. Your property's in the way. So some of the properties were literally right where the third track was going to be built. So they had to be taken or demolished, or, they are demolished. Actually, they're taken and then they're demolished.
And this is done in part in the name of safety and improving public infrastructure and creating a better, faster railroad.
That's right.
And now, if your neighbor or some developer wanted to buy part of your property to make a bigger property to add to their parking lot, you still have the right to negotiate with them.
Absolutely.
And protect your rights, and you should consult a lawyer and an appraiser about doing it, but they don't have the right to take it.
That's correct. Private entities don't have the power of eminent domain. It's really just the government. And interestingly enough, though, we were talking about this a little bit earlier, you and I offline, and I just want to mention this Supreme Court case. Just bear with me. So in 2005, the United States Supreme Court came down with a decision called Kelo versus City of New London. And in that decision, the court said that the alleviation of urban blight is a valid public use, and a government entity can acquire property by eminent domain and then turn it over to a developer to redevelop the blighted area. And since that case, we've seen a lot of that happen. And it's happening right now in Long Island in Suffolk County in the Ronkonkoma hub. We actually have a few clients out there, more than a few clients out there in the Ronkonkoma hub. One of them has been pretty vocal with his opposition. He's the owner of a bus company, and he's in the way of the next phase of the Ronkonkoma hub project. Governor Hochul actually did the groundbreaking for phase 2 of the project. I think it was in February or March of this year. So the project's going forward. We tried to negotiate with the developer and the town, and we were not able to come to an agreeable number to sell the property in lieu of condemnation. So about a month ago, the town of Brookhaven IDA, Industrial Development Agency, voted to condemn my client's property. So we'll be seeing them in court and fighting the valuation there.
And part of the issue there is the difficulty and the expense of your client getting a similar property that can serve them the same way.
That's right. That's a very big issue for a lot of clients. They have their property, they have their business, they're running their business. They don't want to go. They don't want to move. And it's not just in Ronkonkoma. I mean, we had this in the Barclays Center in Brooklyn when they were building, the Barclays Center. You have this all over Penn Station. It's going to be happening. You hear it in the news. People are saying, no, they don't want their buildings, torn down and razed. They're happy the way it is. But there's a general project plan. People are in the way. And people don't want to move their business, and it's very expensive and it's very stressful. And the government is supposed to help you with relocation. And they do, to an extent, offer you, some guidance on relocation. But in the end, it's really up to you. And
urban blight is a loose term. I mean, in the beginning, it might have meant the slum or decayed area. Now it could just mean they have a different use for it.
It's still sort of a blighted area, like an underutilized area. I mean, if you see, especially in the Ronkonkoma hub, right across from the Long Island Railroad, it's not being used to its full potential. I mean, I disagree with the values that have been offered to our clients and the way that this is being done. I think they're being railroaded, but here and Penn Station and Barclays Center and a lot of other places where this has happened. East Harlem, we had this in 125th Street. I mean, there's a bunch of cases that we've been involved in, a bunch of proceedings. When they take these properties, they're not really being utilized to their full potential. Maybe the buildings are a little bit run down, a little shabbier. And what they do is, they take these properties and they raze them to the ground. They demolish them. And, a couple of years later, you drive by and you're like, wow, look at this beautiful new shiny apartment building. So,
and part of it is if there's an important public purpose involved, like a bridge or tunnel or maybe a parking lot or
affordable housing.
Affordable housing.
Yes.
And can the person who owns the property try to challenge the purpose of the intended taking?
Well, they can. That's what I was talking about, the 207 challenge. But in New York, anyway, it's different in other states. Every state has their own eminent domain laws. But in New York especially, 99.9% of these challenges fail because almost everything is considered a public use in New York. I mean, if you're going in and they're building a bridge or they're building a school or they're building a new hospital or they're widening the roadway or they're expanding transit or any of it, and you're saying, well, this isn't a public use, this is not going to benefit the public in any way, you're going to have a really hard time winning on that argument. The only way that you can actually win a 207 challenge is to prove that the government missed a step. They didn't do something, they missed a step in the public hearings or they missed a step in their environmental assessments. But in those cases, the court generally says, okay, the government missed this step, and this step, but they can go back and start over and do it again. So eventually your property is going to be taken either way.
Can it also be taken, let's say, for a prison or a homeless shelter? And would people have grounds for challenging the suitability of that facility in their backyard?
So in the city of New York, they do what's called a ULURP, Uniform Land Use Review Procedure, and it goes from, it goes in front of the city council, and it goes to the community boards. And a lot of people, they have these public hearings, and people voice objections. But interestingly enough, we closed 2 different deals in lieu of condemnation for homeless housing for formerly homeless families in New York City, in the Bronx and Manhattan. One was closed in 2020 and one was closed in 2021. It was highly publicized in the newspapers. But yeah, permanent affordable housing for formerly homeless families is definitely considered a public use.
And the neighbors don't really have a ground for challenging it. Just the property owner who can challenge the compensation they're being given for their property.
That's right. I mean, I think I know what you're asking. I think you're asking more about what the homeless shelters and moving the homeless people up into hotels on the Upper West Side. That's a little bit different. But, building a homeless shelter or housing formerly homeless families that are no longer homeless and, have gotten themselves together and they have children and they want to, have a permanent home for their children, it's definitely considered a public use under the laws of New York.
I'd just like to remind our listeners that you're listening to Law You Should Know. We're talking with Attorney Jennifer Polovetsky. She is of counsel with the firm of Herrick Feinstein, and she's co-chair of their Eminent Domain practice. As you can hear, she's an expert on it. If you've missed any portion of this program or you want to tell someone else about it, just go to the podcast at nccradio.org, and you're listening to WHPC 90.3, the voice of Nassau Community College in Garden City, New York, celebrating our 50th anniversary on the air. Jennifer, what about the tax benefit? Are there some kind of tax implications to the person whose property is taken, either good or bad?
Actually, the tax benefits are pretty good. So most people who sell their property, let's say it's a commercial property, an industrial property, basically any income-producing property, they have to do what's called a 1031 tax-deferred exchange to avoid, capital gains tax on their transfer. In condemnation, you get what's called a 1033 tax benefit. So there's no 1031 exchange agent. You don't have to go through all of those hoops. And you automatically get 3 years plus, I believe it's 2 one-year extensions. I'm not a tax attorney. We do have a fabulous tax department at Herrick that does help our clients in condemnation deal with their tax issues. But yes, there are definite tax benefits to a condemnation. You get a 1033, and you basically you skip all of the headache with a 1031 tax deferred exchange.
Okay. So. And you yourself, as the attorney representing the owner of the land, you're trying to help them get full value for the land and a timetable they can work with, and maybe some kind of suitable replacement land.
That's right. So we get, if it's not always land, sometimes there's a building on it too. Okay. So if the highest and best use is the existing use, then we get them paid for that. If the highest and best use is something else, then we get them paid for that. I mean, you might have an office building that, is 2 or 3 stories, somewhere in Nassau or Suffolk, but, you can prove that either you have a reasonable probability of rezoning, that if you filed a rezoning application, you have basically it's like a 51% chance. It's like a preponderance of the evidence standard to get a rezone. Obviously, you'd need we have zoning experts opine as to, the probability of that. That's included in an appraisal report. But going back to my example, you might have a 2 or 3 story office building, but the highest and best use for that might be, a 10 or 12 story residential tower. And that might bring you more income. So then it would be valued based, as a development site, as a multifamily residential.
And it's based at the time of the condemnation.
That's right.
So if things took a turn for the worse, the real estate market went sour, there was no longer a possibility of getting the full use of the property because of economics, they're still entitled, your client's still entitled to the compensation on the day of the taking. That's
right. Everything freezes on the date of the taking. We call Eminent Domain Alice in Wonderland world because it's almost not real. I mean, it's real, it's the law, but everything freezes as of the date of the taking. It's a highest and best use analysis. I want to point out that commercial tenants get to claim a separate award for their trade fixtures. So I like to use a pizzeria example. So if I own a property and you want to rent my space and build out a pizzeria, and I gave you a vanilla box, there's nothing in the property, it's just 4 walls and some HVAC. That's it. You build out this fabulous pizzeria restaurant. You put marble. You put coal-burning, coal-fired ovens. Whatever it is that you do, and eventually the building gets taken by eminent domain. Well, I get the value of the real estate based on a highest and best use analysis. You get to claim for the value of your trade fixtures, which is all of the improvements that you made that are used in your business.
And this is the tenant.
That's the tenant. And it doesn't go against the landlord's award. So in New York, as opposed to other states, the landlord and the tenant don't have to fight.
So a residential tenant could get the value of their...
Commercial.
This is on commercial.
Yeah, residential tenants don't really make improvements like that.
We just have a moment or two left in the program.
Sure.
Give us your contact information and perhaps your website where someone can find out more about Eminent Domain.
Sure. Again, my name is Jennifer Polovetsky. I can be reached at 212-592-1417. My email is jpolovetsky, JPOLOVETSKY at Herrick, HERRICK.com. And I'm the co-chair of the Eminent Domain practice at Herrick Feinstein in Manhattan. We are at 2 Park Avenue, New York, 10016.
And of course, you handle matters all over Long Island and all over New York State.
That's correct.
On this issue.
That's correct. And Herrick is a full-service real estate law firm, so we handle all real estate issues.
And the idea of eminent domain, this concept goes back hundreds or thousands of years?
That's right. Goes back to William the Conqueror.
And the concepts really are similar to what they were back then, just the economics have caught up with the 21st century?
Well, the laws have changed a little bit, but yeah, pretty much, we have cases from the 1800s that are still good law. I actually sent a colleague a case today from 1969 because she had a question about an issue, and I sent her the case and I said, this is still the prevailing case on the matter.
And you can help someone if they're a homeowner, a property owner, own a commercial building, or they're a commercial tenant.
That's right. We can help anyone.
Okay. I'd like to thank Jennifer Polovetsky, and again, that's Polovetsky, for being our guest on Law You Should Know. She's with the firm of Herrick Feinstein in New York, and of course, she handles matters out here on Long Island and all over New York. If you missed any part of the show, or you want to tell someone else about it, please go to the podcast at nccradio.org, and please join us next week at this same time for another program of Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, celebrating our 50th anniversary right here on 90.3